Categorically and unequivocally, I have never had any communication whatsoever with any attorney about this matter outside this courtroom. Each litigant that appears in court should be able to trust that the decisions made are based solely on the facts and the law governing that particular case. We are on the record in the matter case D22D. Please confirm your appearances.
Good morning, Your Honor. John Jones, bar number 6699, appearing on behalf of the plaintiff, who's present in court.
Good morning, Your Honor. Curtis Rawlings, bar number 6790, appearing on behalf of who's present on the side.
Good morning. This is the time set for a hearing on plaintiff's motion for reconsideration, defendant's opposition, and plaintiff's reply. Any stipulations to report on?
No, Your Honor.
Okay. Based on the papers on file, you may be seated. I note the following. Local rule and administrative order authorize the court to issue orders based on the papers. This is necessary and helpful to maintain efficiency in case management. As a reflection of the time element, it is now 9:54 in the morning. This is her third hearing scheduled at 9, and in theory we have 6 minutes to complete this case before my 10 o'clock calendar. Now obviously counsel understands that's not how it works, and we'll spend the time necessary on this matter, but from a case management perspective, the administrative order and local rules allow the court to issue orders based on the papers. The court issued its order regarding the August 13, 2024 hearing related to defendant's motion seeking a stay of the court's orders with respect to the division of assets and payment of attorney's fees. Plaintiff thereafter filed her motion for reconsideration on August 23, 2024. Now, as a preliminary observation, I concur with plaintiff's argument in the motion that some form of security is appropriate to secure the division of property and potential payment of fees pending the appeal. Such security includes the potential posting of a supersedeas bond or some other form of security as identified by plaintiff in her motion. Defendant somewhat acknowledges or perhaps even consents to a form of security in his opposition. I believe that with a modicum of cooperation and reasonableness, that a stipulation is possible to provide both parties with security pending the appeal. However, I find it would be inappropriate for me to issue any orders in this matter at this time because of what is in the nature of a request to disqualify me from this matter. Specifically in a section entitled, quote, the appearance of impropriety raised by plaintiff references, quote, information which has come to light recently regarding potentially improper conversations involving this court. A related footnote suggests that, quote, any potential harm can be allayed by a recusal. Plaintiff further alleges in the motion, quote, stated that the award of attorney's fees would definitely be reversed as Judge Duckworth had told the attorney allegedly outside of her own counsel that he has never had a case where an award of attorney's fees was upheld on appeal, close quote. Further, plaintiff states the defendant stated, quote, Judge Duckworth had informed his then counsel, Attorney Kelleher, but refused to disclose the identity of the source of this information, only telling that a credible source relayed this information to him, close quote. The inference from these declarations is that I had ex parte communications with defendant's attorney about this matter. Let me preface my statements for the record stating categorically and unequivocally that I have never had any communication whatsoever with any attorney about this matter outside of this courtroom and on the record with attorneys for both parties present. Let me repeat. Categorically and unequivocally, I have never had any communication whatsoever with any attorney about this matter outside this courtroom and on the record with attorneys for both parties present. Why is this important? A fair and impartial judiciary is essential to an effective judiciary and the administration of justice. It's fundamental to our process. Each litigant that appears in court should be able to trust that the decisions made are based solely on the facts and the law governing that particular case. The issue of disqualification should be heard by the chief judge or the assigned presiding judge. Thus, prior to adjudicating the motion, plaintiff should have the opportunity to present her request to disqualify to the chief judge. I use this opportunity, however, to make a record. I believe this is imperative as it relates to any future proceedings regarding the disqualification request. First, I have no connection whatsoever to this case, the parties or their attorneys, other than the fact that the matter happened to be assigned to me. Civil domestic cases are randomly assigned to departments and generally are reassigned only by peremptory challenge, disqualification, recusal, or administrative order. I happened to receive this case randomly following the filing of a peremptory challenge. I did not ask for this case, and I have no other connection to it. Let me also emphasize that I would welcome the reassignment of this case or any other case assigned to my department. Sometimes I believe there's a feeling by litigants and attorneys that as judges we desire to keep the cases we have. That's just simply not the case. However, and this is significant, Nevada recognizes what is frequently referred to as the duty to sit, and I take that very seriously. The Code of Judicial Conduct Rule 2.7 provides that, quote, a judge shall hear and decide matters assigned to the judge except when disqualification is required by Rule 2.11 or other law. In comparison with the total number of cases that I have lost due to peremptory challenge or recusal, I've been on the receiving end of a disproportionate number of cases reassigned by way of peremptory challenge, and thus I understand the burden created on the receiving department when a case is reassigned, having been on the receiving end. And those statistics are available for public consumption in terms of requests by counsel or anyone else in terms of the number of cases that are reassigned from each civil domestic department by way of either peremptory challenge or by recusal. With respect to this matter, I emphasize that at no time have I ever communicated with either party's attorney, past or present, about the divorce matter outside of the courtroom and on the record. Both parties need to understand that there have never been any such communications. In fact, both parties and counsel should know that I have not even seen Mr. current or former attorney outside of the courtroom for several years. The only attorney that I have seen outside of the courtroom within the past several years is Mr. Jones, who I saw about a week and a half ago at the Family Law Conference. I don't recall seeing Mr. Rawlings. I don't know that if he was in attendance. I did not see Mr. Rawlings. I did not see Mr. Kelleher. I don't know if he was in attendance. I did see Mr. Jones. And he was the only attorney I saw at that conference. Beyond that, I did not see I haven't seen any attorney outside of the courtroom. Serving as a judge is somewhat of an isolated existence. And I don't say that in a complaining way, to be very clear. It's just the nature of the position that I hold. It's a very private position. I don't socialize with active practitioners in family law at all. And I have no social media whatsoever. That's not prohibited for judges to participate in social media, but I have no social media accounts, and I don't suffer from what I believe is referred to as FOMO. I'm not missing out on anything. It's a very private, isolated existence. And I have no social interaction whatsoever. And as I indicated, outside of this courtroom, when we are on the record, I have neither seen nor spoken with Mr. Rawlings, Mr. Jones, or Mr. Kelleher, and I believe that's the total sum of the attorneys that have participated in this case. I see you in court on the record, and to be clear, all three attorneys are attorneys of record in other cases that are assigned to me. With respect to the specific issue that is part of this alleged discussion, it is also important to make a record. The issue of attorney's fees is a frequent topic of discussion and debate for both the bench and the bar. Prior to taking the bench, I spent 18 years in practice as an attorney, primarily focused in civil domestic work. I served on bench bar planning meetings, I served on the Family Law Executive Council, I served as chair of the Family Law Executive Council for the state of Nevada. And a common discussion point throughout those 18 years was the lack or insufficiency of attorneys' fees awarded by district courts. That was a common complaint. And I was right there as an attorney complaining to the district court judges at the time of the lack or insufficiency of attorneys' fees awards. In the 16 years since I've been on the bench, I've started to take note of the frequency in which such awards are reversed. And I recognize that for every attorney's fees request, there is almost always an opposition to that request. And based on this history, I've made the observation in other cases, not just this case, but in other cases, that there has not been a single occasion in which a decision I was made that was appealed, that an attorney's fees award was affirmed. It's not for a lack of findings, not for the lack of a Brunzell analysis. Those are always included as part of my findings and orders. Now, to be clear, I don't know that attorney's fees awards generally are the focal point of any appeal or the sole issue on appeal. Oftentimes, it's somewhat of a throw-in issue, and I say throw-in not signifying that it's a meaningless issue. It's a significant issue, but it's an issue that's appealed along with other issues that are sought on appeal. In contrast, I don't recall ever being reversed when I have denied an award of attorney's fees. I have noted these observations with respect to attorney's fees in general in other cases. And it's not lost on me that the attorneys involved in this case are attorneys of record in other cases assigned to my department. In fact, I have no doubt that Mr. Jones and Mr. Rawlings will convey my observations stated to you today to future clients in future cases that might be assigned to me. That does not mean that I'm communicating with them about those cases or those clients, because I don't know who they are or what the circumstances are. But I emphasize again, to assure both parties that at no time have I ever discussed this particular case or even the issue of attorney's fees in this particular case outside of the record on this case with the attorneys present. Now, I know, Mr. Jones, you were at the Family Law Conference, and just as a follow-up to this discussion, the final presentation at the Family Law Conference was a case law update. I don't know if you were present for that.
Not sure I was.
In that case law update, one of the discussion points related to several decisions regarding attorney's fees, several reversals of attorney's fees awards. One of my colleagues, Judge Hoskin, asked the question that I posed previously, because this has been a discussion topic among the bench and likely among members of the bar as well. But Judge Hoskin posed the question to the presenter: if you are aware of any appellate decisions, published or unpublished, in which a denial of attorney's fees has ever been reversed in civil domestic practice. Now, at the conference, no one could identify, and I'm not saying that they don't exist, perhaps there is a decision. I am not aware of any appellate decision where a district court's denial of an award of attorney's fees was reversed. And if you are, feel free to share that information, but I'm not aware of any published or unpublished decision in that regard. Again, attorney's fees awards generally are not appealed. In civil domestic matters, my experience has been they're not generally appealed as a standalone issue. It's usually in addition to other issues. So perhaps there is some precedent out there, but I'm just not familiar with it. It does beg somewhat the question about really the significance of the American rule when it comes to the payment of attorney's fees. And whether or not there is a message that we should be receiving as members of the bench and the bar in regards to the issue of attorney's fees. And so these are observations I've made in other cases, and it's possible that attorneys past, present, in other cases have heard me make these observations as time has passed, and I've taken note of the approach from an appellate level of the issue of attorney's fees. Now, to be clear, I stand by my order that awarded the plaintiff attorney's fees. I'm not taking that back. I stand by it. Am I confident that the appellate courts are going to affirm my decision? I'm not. And that's how I've expressed it in general as it relates to other cases as well. But still, my approach was to equalize the payment of fees pursuant to Sargent, if that still remains good law. The irony is, as I look at the issue of fees, and it's my understanding, because the stay was sought by the defendant, it's the defendant who is seeking appellate relief from my order awarding fees. The way I view it, if anyone should take umbrage or be upset with my award of attorney's fees, it's the plaintiff, because there was a significant amount more than I awarded that was incurred in fees. And so an argument could be made on plaintiff's side that the award was too low. I simply looked at the amount that the defendant had paid, and from a Sargent perspective, looking at Brunzell and analyzing the case, the work that was performed, and this was an extensively litigated case, very time-consuming for the parties and for the court, I found it was appropriate to equalize or level the playing field, which is what I thought we were told to do in Sargent. And so I made an equalizing award of those fees as part of my order that is now the subject of an appeal. So I'm not taking that back. As much, and to be clear, as much as I would welcome the reassignment of this or any other case to another civil domestic department, there's not a basis for me to recuse, because I've had absolutely no communication with anyone about this case, about these issues. And sometimes I recognize statements are made between parties outside of court, and emotions get heightened. Sometimes things get misinterpreted or misperceived, and I recognize that. But I want both the plaintiff and the defendant to understand that I treat very seriously my role as the judge that presides over your case. And nothing that happens in your case should ever be influenced by any discussion outside of these four walls, beyond the evidence that is admitted and that I consider privately in chambers. And I want to offer you that assurance that I treat that very seriously. And I am very, very averse to any communications, any attempts to communicate to the court outside of the courtroom. My staff will receive communications from various individuals from time to time. They rarely, if ever, tell me about those communications, unless it's just a procedural issue. My staff insulates me from the outside world in terms of anything that happens or communications that may be offered to them, because I treat that role of the judge very seriously in my approach. Any questions?
None whatsoever, Your Honor. And as you note, there hasn't been a motion to disqualify you filed, because that comment was made, if for no other reason, to put into stark reality the harassment and the behavior of the defendant that continues. Meaning, this whole appeal would go away if she'd just go back and be his wife again. Okay, that's what she has to deal with because of the stay. Okay, so while his theme has always been, I know what's going to happen, you're not going to get this, you're not going to get that, and he's regularly made implications, that the fix is in, and obviously I've told her no, because I know how seriously you take it. Okay, and that's why there hasn't been a motion to disqualify, but it does put into stark reality the fact that you entered an order granting a stay to the person with all the money, right? And the person who has no money under your order, but for that which you gave, gets $0. Now, as I argued in the initial opposition to the motion to stay, money is never irreparable harm. In fact, the case law that I cited, no matter how big the amount of money, it's never irreparable harm for a stay, okay? So we know that, okay? He can't show you, he didn't make a meaningful argument that he has a likelihood of success on appeal on the house issue or the fees issue. You made the appropriate findings on fees. You made the appropriate findings on, there was substantial evidence to support your order, okay? When I read your August 13th order, first of all, I'm always disappointed when I don't get to come to court and argue, as you know. But when I read it, and it seemed to imply, well, both parties are clearly unhappy with the order, therefore I'll stay. We filed our appeal based upon the prenup only, okay? Our issues on appeal are whether the prenup should have been found to be valid in the initial hearing, and whether or not you interpreted it right. That's what we were appealing, okay? Yes, we could have said, sure, we probably should have gotten a greater award of fees, because otherwise, the property that she does get, she's gonna have to consume to pay my firm the $100,000 plus that she owes me, even in the presence of the $30,000 award. But the biggest issue on the stay, which is what we've asked to reconsider, we didn't ask you to reconsider your orders, we asked you to reconsider the granting of the stay, is your alimony award of $2,000 specifically said, because she's getting this money from the house, I'm only going to give her $2,000. So we are now in a position, because of the stay, that she doesn't have enough money to live. You saw her financial disclosure form we filed. She's upside down over $2,000 a month. She's had to say to him, I don't have money for food for the children, so I need you to keep the children. So he's then complained to her, well, if I'm gonna have the kids more than half the time, I'm gonna stop paying child support. Now, his lawyer, I'm sure, told him not to do something that foolish. But the next thing will probably be a motion to change custody on the basis of de facto arrangement. He's threatened it to her over and over and over, right? I'm just gonna drop the kids off your house. She's finally got a part-time job. He's trying to interfere with her ability to even do that. While she goes to school, she's got a part-time job, she's upside down $2,000 and change per month. But your alimony award, absent the award of the attorney's fees, but absent primarily the award of the house equity, your alimony award is absolutely insufficient for these facts and circumstances, and your decision and your findings makes that really clear, that because I'm giving her this property, she doesn't need that much alimony. You said those words to that effect, okay? So now that there's a stay in the absence of irreparable harm, and when we talk about irreparable harm to the respondent, right, you characterize her as an appellant as well, but as it pertains to this issue, she's the respondent. She didn't appeal the House decision, she didn't appeal the fees issue, right? The irreparable harm she's suffering, it's for her, it's for the kids, it's massive and it's real. It's, I can't feed my children. I got a job. I'm going to school. I get the $2,900 a month in support from him every month, but my expenses are $6,500, so the $2,000 I can make still leaves me short. Okay? That's irreparable harm. Hey, I don't want to have to advance $280,000 of my $1.6 million in wealth. That's not irreparable harm. So the part that I wanted to, I don't file a lot of motions for reconsideration, particularly under circumstances like this, but I don't think, the initial thought, well, both parties appealed, so maybe I should just stay it and let them fight it out. We didn't appeal any part of your decision other than the prenup issues, okay? So from that perspective, your order in granting a stay, I know you talked about him having to post security, still doesn't change the analysis. The analysis, is he going to be irreparably harmed? We already know that Nevada law says no, okay? Is she going to be irreparably harmed? She already is. She doesn't get to spend time with her kids because she can't afford to take care of them. She doesn't have the money to get a place. He talks about, well, I gave her money. No, he bought her out of the furniture and furnishings in the house. That's the only dollars she got, was rather than her taking half and him rebuying, he gave her a check for the stuff. Okay, that wasn't any partial payment of anything that he owes her under your decree. So as a result of the stay, she's getting nothing, and she's getting alimony that you've already said would be inadequate but for her receiving the house equity. So I go back to the stay analysis. Irreparable harm we know we don't have on his side. You can judge whether or not you believe that her inability to care for her children is something that is irreparable harm. I'd like to think it is, particularly to the kids. But she also has to deal because he doesn't owe her a nickel now, and he won't for 2.5 years. Sorry, but that's how long these appeals on just dollar issues go, 2 to 3 years. So let's say 2.5 years. He's going to continue to say, oh, well, all this can go away if you just come back and be my wife. Or better yet, if you sleep with me, okay? That's what she has to deal with because of the stay. I know that wasn't your intention. The only reason I filed a motion for reconsideration is I know you wouldn't have intended the world that she and the children are in by granting the stay if you, A, had perceived that she's not appealing the other parts of the decision, and 2, what the ramifications of her not having sufficient dollars is. Because they're big and they're long-term and they don't just affect her, they affect the kids. So when you look at those factors, and he didn't give you a basis for saying that he's going to be likely to be successful on appeal. So when you look at all of the factors, the subject of the appeal won't be defeated. Okay? If he ends up getting the equity in the house back, which again was supported by substantial evidence, he's still going to owe her dollars over time, so that can always be recouped over time. I don't think it would happen. I don't think they're going to reverse on that issue given the evidence that was presented at trial, but that's neither here nor there. The stay analysis is very clear, and he doesn't meet any of the criteria, and mom and the children are being irreparably harmed by the stay. So we would ask you to reconsider the stay and recognize, A, that your alimony award was linked to the amount of cash she was getting, as any good alimony analysis would include. You did include it, and so she doesn't have any of what you intended her to have for one reason, it's the stay, and he can't meet any of the criteria for the stay.
All right, let me hear from Mr. Rawlings.
Thank you, Your Honor. First of all, these ongoing allegations of harassment, his wife, his appeal would be dropped, he's trying to force her to sleep with them. These are absolutely nonsense arguments that are based upon nothing at all. It's a waste of the court's time, and I even hate to spend time addressing it, but they're false. Is she a party that has no money to live upon? I mean, that's what counsel said. She has no money. That is utterly absurd. She was awarded $2,000 in alimony. That was not based upon a property. I'm sure that was a consideration, but a property equalization. It was based upon the fact that I have a client that's 75 years old, retired, and he lives on fixed income. That fixed income is dramatically dropping through the pendency of the case and all the money that he's been paying out, not just the alimony or child support or anything else, but everything that we put in our initial pleadings for a stay and in our opposition. There is no denying those things. The other thing that I want to point out is that all of the arguments that counsel just made were all made in his opposition to our original motion to stay. These are not new things that would justify a reconsideration. These are not new things that the court didn't have in front of it to consider when Your Honor made your initial order. The only thing that I saw from his pleadings, why he was so upset about not having oral argument, was that he wanted to update his client's medical situation at the time of the oral argument. Well, we now have the circumstances of the medical condition. She had kidney stones, something that might require 2 or 3 days. And look, I'm not discounting that. I knock on wood and thankful that I've never had that. I know it's a painful condition, but it's not something that justifies going 8 weeks without seeing your kids. And if there was an evidentiary on this, you would see text messages between the parties where it's not about money. And talking about, since it was brought up about her income, well, she's got a total income right now of $49.53, still choosing to work just part-time, being capable of working a lot more. And I know that was part of the consideration that Your Honor gave when considering these, that she would not go out and work, even though she had been advised to do so throughout the pendency of the case. But counsel relies on this financial disclosure form, which Your Honor, I would point out, there was no financial disclosure form in the initial proceedings when we filed the motion to stay, the opposition, and our reply. So it's only on the reconsideration that there's a financial disclosure form filed. Well, the statutes and the case law basically say reconsideration is not a valid basis when there was something that could have been presented but was not. So it's really to repair maybe a mistake that was made by not filing a financial disclosure form. But the one that was just recently filed shows the exact opposite of what counsel's arguing. Claims unreimbursed medical expenses of $450 a month. Well, we haven't seen anything that substantiates that. It's kind of doubtful. There's insurance. Maybe there is a number. $450 seems pretty high. $1,500 in groceries. Judge, for the last 8 weeks, she hasn't even taken the kids. My client had his son that wanted to go and pick up some things from mom's house. It was supposed to be her week. And so he drove him over there. She left because she got a text that he was bringing her just to pick up some items. She will not take those kids. And for 8 weeks, yet she files an FDF that says $1,500 in groceries. Membership fees at a gym, $100. Internet, Cox cable, $140. Rent of $2,400 she lists, knowing that my client helped her financially to pay a year in advance. And even counsel's opposition confirms that she will not have a rental payment until May of this year. Now it's interesting because he also congratulates his client, and he should, that she's gone through something like 8 classes, completed 8 classes in 12-month period. She's got 13, I think it was 13 left. Well, what's that? Completed 18 and has some number left, 13 I believe. Well, at the pace that she was on, she would be completely done with her college education by the time she has her first rental payment in May. But that being set aside, she doesn't have $2,400 in rent. Cell phones, $272 she lists. Swear her in, my client's been paying all of those cell phone bills. Credit card payments she lists. It's all been coming from my client. Maybe it stopped this month, but it's all been coming from my client. She's been able to pay her credit card bills. Yes, was there an amount that was paid towards some furniture that she left behind? Yeah, and we credit that. He gave $47,000, a small portion of that being for that furniture she left. He then helped her buy all new furniture in a 3-story townhouse that has 4 bedrooms, 4 bathrooms, and it's paid up for a full year. She has almost no expenses related to this, and when she comes in and says that she's foregoing her visitation or her timeshare because she can't afford it, that is blatantly false and not supported by the record. So, Your Honor, we don't see any cause for a reconsideration. There's nothing new that Your Honor didn't consider in the initial proceedings with regard to the security. Yes, we had suggested it, and from the opposition from the reply that I saw from Mr. Jones, we are more than happy to sign off on an order that my client cannot encumber that property. I think our pleadings say that there's about $400,000 in equity in that property, far more than what he would owe if the Supreme Court denies our appeal. So we will enter an order that he cannot encumber that property at all, and that will be the security. It will be there if there is any kind of request to sell the property based on circumstances that might arrive. We would deal with Mr. Jones, try to come to an agreement where an appropriate amount of proceeds would be put in his trust account pending the outcome of the appeal. But that being the case, and we also addressed this, I'm confident, in our initial motion to stay. That was all ruled upon, and Mr. Jones filed a full and detailed, I think it was a 20-page opposition. So everything has been heard. Let me just make sure that I'm not missing something. The child support, Your Honor, I mean, all of this bashing, I've got to just be clear. When a guy is paying, or a mom is paying, whoever is paying child support, and for 6 weeks that parent doesn't take any time, the question is, especially to a non-lawyer, is going to come up, why am I paying for support for the child when I'm incurring all these extra expenses by having them 100% of the time? I think the deadline came, he contacted me on this issue to get advice and direction. I think it was a couple days before I got back to him and had a discussion, and he made that payment. But we're gonna drag him through the mud because he was a couple days late on a support payment when he's timely on all of his support. And I just wanted to make sure that was clear, along with all of these allegations and constant history of abuse that's well documented and continued abuse references. That he's got this money to go to concerts all the time and to go on all these lavish trips. He's been to one concert in the last 20 years, one. It cost him about $90, okay? He's been on one trip, and that was a trip where he took the kids on I think it was a little rafting venture. It was nothing expensive. I think it was addressed in our prior pleadings, in fact. Very minimal cost, nothing else. So, these allegations that are constantly thrown around, the truth is exactly the opposite.
Let me just ask some follow-up questions. Is the defendant seeking appellate relief of the alimony decision? My understanding was it was the division of assets and the award of attorney's fees.
I don't think I don't believe that that's part of our appeal. I would point out this, Your Honor, though, that the initial motion, the reconsideration motion, nor any kind of counter motion prior to that, ever asked for an alimony modification. I mean, counsel, even in his reconsideration.
I'm not, here's my question as it relates to that, because the award that's stated in the court, in the decree is $2,000 a month for a period of 60 months, commencing in the month of April 2024. So we're about 6 months into the term of the obligation. I inquire because Mr. Jones pointed out, and it is part of my decision, I referenced the fact when I'm analyzing the alimony factors, the amount of property awarded to the plaintiff as part of the division of assets, that it's not necessarily income producing. I made it very clear that I didn't view that as material in terms of it being an income producing asset. However, but for her receipt of those funds, my comment in the findings specifically stated that but for that award of assets, her need for additional spousal support would be greater. Given the timeline of the appeal, and I have no reason to dispute the fact that you're probably looking at 2 to 3 years for the appeal to take place, the question becomes, if the issue which was raised ultimately in the initiating motion for the stay is that if the property is paid, the defendant will have no ability to recoup that money from the plaintiff. If there is an alimony award, there obviously is an amount that can be used for purposes of recouping any amount if the appellate courts determined that the property award was an abuse of discretion. That could be used for that purpose, and not the entire amount. So even if I'm looking at an amount, say 2 years of alimony, by the time the appellate course has run its path, we have probably at least 2 years left of alimony. That's $48,000. So what would the harm be to the defendant of requiring him to advance at least that much, understanding that on the back end, if it is reversed and ultimately the appellate courts determine that any award of assets was an abuse of discretion, it could be recouped, that amount, not the full amount, could be recouped through some type of an offset against the alimony. Is there any reason not to approach it from that standpoint?
The only concern I would have paying $48,000 in advance is whether or not he's got the ability to do it. I think that one of the reasons, or one of the things that has to be considered, is that he has a certain amount of principal assets that are paying that passive income. He is, during the pendency, and he in fact was just showing me some charts prior to the hearing, how much he had to take from that principal during the course of the pendency was about $500,000. So that decreased that, and whether he took another $50,000, how that affects that passive income and the money he gets every month. Yeah, Your Honor, are you suggesting that he would pay that in advance as a lump sum and for the next 2 years wouldn't have to pay that obligation on a monthly basis?
No, what I'm suggesting is, if the appellate court reversed my decision and deemed that it was an abuse of discretion to award any property to the plaintiff, that there would be an obligation, because that's why I asked the question about alimony. If that is not being appealed, that is an obligation that I could use to recoup any monies that I advance
I see.
now. I don't necessarily, in terms of the stay, let me just offer this as well. Because the appellate courts can entertain the issue of a stay independent of any decision I make. So to the extent
They're
either
gonna
of you
give
disagree.
deference to you, Judge.
They
no,
do?
On the issues of stay, they almost always do.
I don't know about that.
I'm not sure about that.
I would disagree, but,
I do a lot of appeals.
well, listen, the bottom line is, and this goes back to, my approach has changed over the years from, as I have approached the issue of stays. Judicially, you're confident in the decision you make, otherwise you wouldn't make the decision. I issued my findings, conclusions, and orders, and generally, in the past, especially in the earlier years, I was reluctant to grant any stays, because essentially I'm acknowledging that there was some type of error committed in my decision and it needed to be reviewed by the appellate courts. There's a specific protocol laid out by case law precedent and rule in terms of how I approach those stays. But more recently, given some of the decisions that we're receiving from the appellate courts, I'm more inclined to grant stays than not grant the stays. And I don't necessarily find that it would be error on my part to grant some type of a limited stay, or at least some relief, recognizing the issue that's been identified in the papers that have been filed, and the security I have perhaps to recoup that amount once the appeal comes back down, if it's determined that in some fashion I abused my discretion as it relates to any of these issues, whether it's the interpretation of the prenuptial agreement or my adjudication ultimately of the issue of property and fees.
So, Your Honor, if I understand it, it's a $48,000.
No.
You're,
I'd rather him make a ruling as to what he's gonna do, and I'd like to have my final remarks.
well, I'm just trying to clarify.
Because there
I don't
is
know if
no
there's something wrong
basis
with that.
for a stay even on the retirement dollars, Judge, because we knew he had the 401k at the time of marriage, and we knew he contributed during the marriage.
It's arguing the appeal.
Yeah, here.
Well, no, I'm saying he still has to show a chance of success on the merits on appeal, and he's gotta show irreparable harm. What I want today is a finding that how he will be irreparably harmed, or that she isn't being irreparably harmed, and that you think he has a likelihood of success on appeal. I need findings. Part of my problem and the reason for the reconsideration was this order from August gave me no remedy. It gave me no understanding as to what you found to be irreparable harm, because you gotta make a finding on that. What you found to be a likelihood of success, because you gotta make a finding on that. And I didn't, there's none of those findings.
Listen, I've stated my feelings as it relates to the likelihood of success. Those findings are interwoven throughout everything I've stated on the record.
Okay, and that's
So
fine with me.
You can approach it in that way. As it relates to the irreparable harm, that goes into, I don't, because of the nature of the issues that are before me, I'm inclined to require a payment by the defendant to the plaintiff of $48,000, which essentially is the equivalent of 2 years of alimony. And the remainder would be stayed with the understanding that security is in the form of the order of the court is that there's to be no encumbrance to be taken out secured by the residence. The residence is not to be sold absent a written stipulation between the parties or permission from the court. And that the principal of the retirement account is not to be liquidated in any fashion.
And are you saying you're not finding that the defendant will be irreparably harmed by complying with the judgment? Or are you finding he will be?
I'm finding he would be if I.
Even though it's just money? I mean, you've read the case that says no matter how much the amount of money, and that's not irreparable harm. This is the Nevada Supreme Court.
I have.
You're saying that it's irreparable. Okay, and that's fine, because that will give me my remedy and I would have that in the order.
Okay, you may include
But
that
you-
as
but-
part of the
but-
order, and again, this may be approached with the appellate courts, but that, given the nature of the decisions and the relief that's being sought through the appellate courts, that effectively, the orders of this court would be defeated if the appellate courts determine, which again, there's some level of reluctance in saying that my decree, my findings in decree are wrong.
Well, you've already said you think they're right, so.
I do, and that's why
So
typically
he
in the
can't
past,
meet
I
that
would
prong,
never
the
grant a
analysis.
It would
stay.
never be met in that circumstance.
But if they deemed that my entire approach to the division of assets and debts, then the entire decree and the ability, if I enforced the payment of those provisions, the entire decree would be defeated. The entire appeal, the issues, if it had been reversed and there was no amount that the defendant owed to the plaintiff, that entire order would be defeated by virtue of the court
Right,
not.
but then she'd be
enforcing a stay.
entitled to significantly more alimony, Judge. And so I think what I have to do next is file a motion to modify alimony. Because $48,000, she can't afford to pay her lawyer. She can't afford to pay me for the appeal. I guess I should file a motion for appellate fees next. But that's what we're gonna have to do if it's $48,000 that she's getting an advance on. But you've given me the findings that I was looking for. And we'll take the next steps.
Okay, I've made my
Thank
findings
you,
and
Your Honor.
orders. Thank
Thank
you.
you.
Who would you like to prepare the order?
I'll be happy to.
Mr. Jones will prepare, Mr. Rawlings will review.
Thank you, Your Honor.
Alex here. I mentioned in my prior video that there were 2 hearings vacated in this case that I was going to mention some details on to get you guys updated. I don't actually have to do that because John Jones, Curtis Rawlings, and District Court Judge Bryce Duckworth actually ended up going over all of those issues in this hearing.